So in the previous lecture, we've already considered the fact that the court is not going to act as a court of appeal when an application is brought under Section 30 for setting aside an arbitrator's award. Now, in order to understand the importance and significance of this rule, that is, the court is not allowed to constitute itself into a court of appeal, we need to first understand what exactly does it mean that the court should act as a court of appeal, since we have to make sure that we are clear about the fact that the court cannot act as a court of appeal. We need to first understand what really does it mean for a court to act as a court of appeal. Only then would we be able to understand the importance of this rule and why it is so important to the overall purpose of arbitration, and later on you will appreciate that if this rule were not in place, then it would simply defeat the very purpose of arbitration. So let's look at this rule in detail so that you can understand all of these details. Now, when I say that the court is not going to act as a court of appeal, this simply means that the court is not allowed, that is, it's not permissible for the court to find out whether the decision taken by the arbitrator was right or wrong. That is, the court is not permitted to look into the merits of the decision. And now you must be thinking, what does it mean for the court to be looking into the merits of the decision? In order for you to understand this, I have thought of a very simple example. So let's say that a teacher, an examiner, is checking examination scripts, that is answer scripts from students after an exam, and let's imagine that this teacher is just looking at all of the answer scripts in a way that the teacher is just focusing on the headings which have been underlined and written in bold by the student, and the teacher is not bothering to actually look at the content of the answer, that is, what is written beneath those headings. So in this situation, if the teacher is not going to actually look at the content of the answer as to whether or not the information written by the student is right or wrong, then in this situation, where the teacher is merely judging the answer on the basis of those huge headings that he or she can see, then obviously the teacher is not going to be doing fair marking. In other words, the teacher isn't giving marks and grades on the basis of merit, that is, the marking is not merit based at all, but is instead simply based on superficial checking. Now, using this simple and everyday example, we can compare the decision that an arbitrator passes and how the court is going to review it. So normally what happens when a case comes from a lower court to a higher court, be it from the district court to the high court or from the high court to the Supreme Court, then in these situations the court is indeed acting as a court of appeal. So when a case comes from, let's say, the high court to the Supreme Court, and remember that this is a case, that means it's not an arbitrator's decision, I'm talking about a litigation matter, that is a suit. So when a case comes from the high court to the Supreme Court, then in this situation the higher court is going to look into the merits of the case most of the time and is not just going to superficially judge the lower court's decision. So remember that going into the merits means actually looking at the content of the decision, that is, questioning whether or not the decision taken by the lower court can actually be set aside on the basis that the lower court's reasoning process was somehow or the other flawed. And therefore, the higher court not only sets aside that decision taken by the lower court, but also has the power to actually take a new decision, that is, come to a different decision altogether based on different reasons altogether. But this is exactly what does not happen when a case comes before the court under Section 30 of the Arbitration Act 1940. Why? Because, like I said, under Section 30, when an application is brought against an arbitrator's award, the court is not going to constitute itself into a court of appeal, and this means that the process that I just outlined, which takes place when a case goes from a lower court to a higher court normally, so that process does not take place when a case comes before the court under section 30, and instead what the court does actually do is simply looks at the arbitrator's award superficially, exactly the opposite of what I just told you. So, when an application is brought under section 30 before the court, then this situation simply means that the arbitrator's award is being challenged, that is, objections are being brought against the arbitrator's award, and the parties expect the court to have a superficial look at the award and see if on that basis alone the arbitrator's award can indeed be set aside. Now obviously you must be confused, how is the court going to decide based on a superficial look only? So remember that the court is just going to look at the award itself and is not going to go into the investigation proceedings that took place on the basis of which the arbitrator reached that award. So the award itself is obviously going to be reviewed by the court before the award is made a rule of the court anyways under section 14. However, remember that what I mean to say by a superficial look is not that the court is not going to look at the award at all. Instead, what I do mean to say is that the court will only look at the award and see if on the face of it there is any error in the award. And now I specifically laid emphasis on this phrase, that is, the court is going to see if there is any error in the award on the face of it. So the main take-home message from this lecture is that in order for the court to decide whether or not an arbitrator's award can be set aside under section 30, the court is not going to look into the details of the reasoning process on the basis of which the arbitrator reached the award. And this is very important. Why? Because normally when a case comes from a lower court to a higher court, then this is exactly what the court does do. That is, it constitutes itself into a court of appeal whenever a case is brought from, let's say, the High Court to the Supreme Court. Then in that specific situation, the court does act as a court of appeal. However, when an application is brought under section 30 before a court, then in this specific situation, the court does not act as a court of appeal, and instead the court only looks for errors that are obvious on the face of the award. Now obviously you must be thinking, how is it possible for the court to only decide whether or not there is an error obvious just by looking at the award itself and without going into the details of how the award was reached, that is, how the arbitrator reached that particular decision? So remember that there is the criteria which is to be found under section 30, that is the certain grounds on the basis of which the court can set aside the award, and we're going to look at that criteria in the next few lectures. But for now, just remember that this particular phrase, that is errors that are to be found on the face of the award, is going to be a little bit difficult at first, but I will explain that in the very next lecture.